Ready. Start. The facts in the case of Canara Bank and another Supra is to the effect that the deceased was employed as a clerk in the appellant bank and was dismissed from service consequent upon a departmental inquiry in which he was found guilty of fraudulently withdrawing an amount of rupees 1,07,000 from the saving account of a customer. Along with him, manager of the bank and officer as well as special assistant was also indicated, and they were also found guilty of negligence in relation to the very same incident. They have filed appeal which came to be dismissed, and they deposited the amount as ordered against them. The deceased has carried the matter before the court, and the court dismissed the petition. Thereafter, the bank decided to recover the amount from the deceased therein. The bank has adjusted this amount from the maturity value of fixed deposit. Due to these factual aspects, the apex court affirmed the decision of the bank. Considering the Rule 12 of the Canara Bank Employees Gratuity Fund Rules, Clause 19 of the Canara Bank Staff Provident Fund Regulations 1994, and Rule 3 into bracket 4 of Chapter 7 of the General Conduct Rule governing the services, the Apex court has upheld the decision of the bank to recover the entire amount from the respondent employee who has committed forgery, which has ultimately caused the loss to the bank. In the case of Brijpal Singh Supra, the fact was that the service of the workman was terminated on 3 July 1987. Feeling aggrieved by the termination order, the workman filed writ petition whereby the interim order the High Court stayed the termination of the workman. In that proceedings, the state of Uttar Pradesh and another filed their counter affidavit stating that the workman never attended the office as per the order of the High Court and that did not care to join the duties. Therefore, he was not entitled to get any pay. Thereafter, the workman, after a gap of 6 years, filed petition under Section 33C, Clause 2 of the Industrial Dispute Act for payment of salary from the date of dismissal till July 1993 and bonus for the years 1987 to 1992. He has solely relied on the interim order dated 28 October 1987 passed by the High Court. The state of Uttar Pradesh has also filed counter affidavit before the Labour Court stating that the writ petition was pending for consideration before the High Court. Therefore, in such circumstances, the Labour Court did not have the jurisdiction to hear and decide the dispute. However, the stop.